Well, thank you, everybody that is joining us today. I do hope that if you have any questions after or as we kind of go through things, please throw it in the chat or alternatively in the question box. We're going to go through kind of the highlights of closing deals, what's going on in the market, what's wrong with my golf swing, and then with as much time as possible, definitely answer absolutely everything that you may want to know about title and escrow from the main man right here, Eric Dahlberg. Great to meet you today.
Yeah, thank you for having me.
Definitely. And to kind of set the stage, could you tell us a little bit about yourself? We mentioned Mel John, who I've known for a long time now, and kind of how your group works together and kind of the track record.
Right. So personally, I started in the title business about 15 years ago. I went to law school at SMU, graduated. I started working with the Small Business Administration doing loan underwriting for disaster relief loans for Katrina. And through that, I started kind of working with some title companies as people were really relocating out of Louisiana into other places and using title companies for the purchases and sales. And I just kind of said, hey, man, that kind of looks interesting. I like the transactional side of things. And so I applied to a job with a title company where Mel John worked, got on with Land America National Commercial Services there. From there, moved over to Commerce Title, which was Syntex Homes Commercial Title Group. And fallout of 2008, 2009 subprime market hit. They closed their ancillary services, such as the title company. And we latched on with a Chicago title group where we were for 10 years before we moved over to Capital Title almost 3 years ago now. So that's kind of our group has stayed together throughout that process. And we've just figured out, from our days at Land America to Commerce Title to Chicago Title and Capital Title that we work together well. We're able to jump in and help each other as we take time off, and have relationships with these clients that have been built over the last decade or two. And as they've gotten to know each other, us individually and as a group, they've relied on us for all their title needs. So it's just kind of been a very good cohesive group.
I love it. And I apologize for laughing. I know that Mel, who runs the group, who doesn't want to be on camera because he's like 135 years old. Amazing that he's still really running the show and out there.
Doesn't look it, by the way. Doesn't look it at all.
No, he doesn't look a day over 99. Sorry, Mel. But I know that he's got decades in the business. I know that he kind of started with law school as well. Are you a attorney, or you just got the fun and exciting experience of going through law school?
I am a licensed attorney, so that does come up to my benefit. As we deal with things, I think if it doesn't necessarily help me from my, knowledge standpoint, it helps me from everybody gives me a little bit more credence because I have Esquire behind my name. But, at the end of the day, there's a lot of people here that have just been in the business for so long that they know the ins and outs. It's just like the legal profession. Sometimes the paralegals are smarter than the attorneys signing the documents. And that just happens to be, the nature of the business when you do it so long and you've seen so many issues and so on. So, it does come into play here and there with some clients, but, it's not something I always, promote necessarily.
Kind of just to start things off, I'd like to ask you to just kind of define some pretty simple terms.
Sure.
Just really kind of for the benefit of anybody watching this, just so we set the stage and then we can start getting a little bit deeper. Let's just start with escrow. An escrow company, what actually is an escrow when we're talking about real estate transactions?
An escrow company is an independent third party where the buyer and seller can come to that party to kind of facilitate the exchange of documents and funds for purposes of closing a transaction. Someone who's signing away a deed, they don't want to give that deed, that legal document away until they know that the funds are, and vice versa. The person doesn't want to put their funds up unless they know that the legal documents are signed. So we facilitate that process as an independent third party, a fiduciary, take in the documents, take in the funds, and help people feel comfortable. As soon as he's got it, he's going to send me my money. He's going to record that document and everything's good. And that's what the escrow service is.
And if I could ask you, I mean, attorneys, we generally are representing a side. Are you representing either the buyer or the seller, or you're just a neutral third party to make sure the agreements get effectuated, worked out?
We certainly have relationships with a party as wanting to use us for our services. But at the end of the day, we are a neutral, independent third party. So where there has been times where there's disputes over earnest money that's put up under a contract, it's not to the benefit of the person who client relationship. It's just saying, well, until everybody signs off on this, I can't release anything to you. That's the purpose of it. So yes, we are neutral. We are independent third party.
Perfect. And we talk about title companies and escrow companies. Title actually means something a little bit different than what a lot of people assume. What does title mean when we're talking about title company or an escrow company?
So title companies are the companies just like they're the ones that they're an insurance company, right? So they're the ones that actually search, do the background searches on title, property, title. And from that determine what documents affect the property, what doesn't affect the property, and then commit to ensure that that transaction. So they're the actual company that does the issuance of the title policies, the insurance aspect of it. In Texas, the title and escrow companies are combined, so the title companies and escrow companies do the same, do both services. In other states, on national scope, other states bifurcate that and they have, separate escrow companies from title companies. So you'll see that a lot on the West Coast, along California, Washington. And so, that's the difference.
When you're talking about insurance, what does actually mean? Is that insuring the transaction itself, insuring something about the real estate, or that piece of paper that goes to the county recorder?
A little bit of both. I mean, the definition of title insurance, I'll give you that so that you know what. It's indemnity insurance predominantly found in the U.S., which insures against financial loss from defects in title to real estate and from invalidity or unenforceability of mortgage liens or ownership interests. So really, it is insurance. It covers both defects when we're examining title, if we miss a document or something comes up in a document that might present an issue, something that you're concerned about of, hey, if I own this property, is this easement going to be an issue, or is this encroachment going to be an issue, or this restrictive covenant going to be an issue? So it definitely insures in against those things, but it also ensures the closing process, right? So if we make a mistake in not paying taxes, we collect for taxes in the escrow process, finalizing the closing statement, taking in the money, we pay taxes, but we miss something, in the closing aspect, it also covers you from those type of issues.
So I'd love, give me a couple minutes. I want to tell you like the craziest dealing with a title company, an escrow company that I got drug into. And I'd love to hear kind of some of the issues that you've had to deal with over the years. And just to clarify, like you are closing properties basically coast to coast. It's most of the states you operate in.
Yes, our office is a national office, so we close in all states. And that's just been the way that I came into the business working with Land American National Commercial offices. We were closing everywhere. So my clients are national clients. Some are headquartered in Texas, some are not headquartered in Texas, but yeah, we deal in all states. Every state's a little bit different. So it creates nuances here and there.
All right. Well, I'm going to tell you my funnest story that actually the title company tried to say, not our problem, which was goofy. I get a call one day, and all this has been resolved and moved on at this point. But get a call one day from this guy that says, I'm a house flipper. I bought this single family residential property from a wholesaler who purportedly bought it from the homeowner, the guy that actually lived there. Well, I got to tell you, was improving the backyard, and they found a dead body in cement in a fountain that was there. And now where it gets really crazy, we think that the dead body was the homeowner that sold the house to the wholesaler who sold the house to me. That was kind of my reaction
Holy
as
cow.
well. And I'm not making this up. This is an absolute true story. And it turned out whoever this homeowner was had a habit of taking in run. And apparently one of the runaways, well, did him in and absolutely lived in his house for quite a while, it sounds like, and built this big cement fountain in the backyard. That's how he disposed of the homeowner's body. And then when they sold the house to the wholesaler, it was really weird because apparently the title company said, hey, you know what? I can't come. I'm traveling abroad. Let me send you my ID. Let me send you all of these notarized documents. Everything is good, but I just can't be there. But if you don't mind, could you wire the funds to this wire, instruction? And that title company closed the deal. And then the wholesaler, he's got, recorded deed, and he's not there for a long time. He flips it to the guy that's calling me. And now all of a sudden he's like, what's going on now? Like, I don't even know where to start other than title company. I don't think I own this house. Pay me back. That's almost like a law school weird, test question of facts. What would you say happens to this poor guy at that point?
Well, I would say you'd have definitely a valid claim against this title policy. Honestly, title policies are there to they insure against fraud and forgery. That's one of the things that they do insure against. So, in this instance, it is part of us as an independent third party when we're closing a transaction to verify the authority of the people who are signing the documents. And so if they took it in and you're even 3 chains down the line, it sounds like, that once that person was insured on their title policy, that they had valid title, even from a wholesaler, that wholesaler hopefully got a title policy too against that one gentleman. But even with fraud and forgery, that would be covered. And so, your title, I will say this, one bad rep that we get as title companies is, like any insurance company, when you make a claim, they're going to first kind of say, hey, well, is that really our fault? Yeah, you might not be covered here. They're going to find any way they can to probably get out of it. But at the end of the day, that's definitely one of the matters that's covered on a title policy. So it's one of the reasons you would want to get title insurance.
In this particular case, you had multiple transactions that happened.
Mm-hmm.
From the fraudulent transaction that did get recorded. And then there was between the wholesaler and the flipper. And that got recorded. Are all the title companies, are all the insurance responsible, or is it just the one that made the mistake?
So that's a good question. So depends on who makes the claim during the process, right? But ultimately, let's just say the guy who purchased from the flipper, he makes the claim on his title policy. That title company has a choice. Well, hey, we can go correct title, so we can go back to the person who truly would have had title, his heirs even, and say, hey, we'll pay you money. We'll pay you to give a deed to this person, so that clears the chain, right? That's one option that they have. 2, they have an option of just paying this guy, saying, sorry, you had a complete loss of failure of title, our fault, we pay you. But then you subrogate your rights to them.
What does subrogate mean?
That means that you give them the right to go out to take your place and go sue whoever they need to go sue down the line, so that they can, recoup whatever expenses they can recoup, right? So if let's say Chicago Title, that's one title company, insured this last transaction into the homeowner now. he makes a claim on Chicago Title. Chicago Title might go, hey, well, who insured that deed to the wholesaler? Maybe it was First American. So now Chicago Title is going to look for First American to pay a portion because, hey, they already, insured this deed. There may be things that go on behind the scenes, but ultimately, whoever makes that claim would get paid by that title company or cleared by that title company. Then the title company can go and work its way down the line of people who might be responsible or sharing the responsibility of whatever expense they had to pay for that claim.
In this case, I mean, if somebody dies on a property, isn't that normally something that has to be disclosed? And if it's not disclosed, is that a title issue or a real estate broker issue?
That is more of a disclosure issue under the property law for closing or entering into a contract for a residential transaction. You're not going to be a title issue per se. That's going to be something. Hey, you didn't disclose this, and I wouldn't have bought the property if I knew there was a dead body on it or someone died in it. Then you have a claim against their failure to do whatever breach they had of the contract and the disclosure aspect of that. But that's not necessarily a title issue. Sometimes they get intermingled and people think that that's, the terms under the contract, certain terms, if you warrant that you did certain things or you say, hey, it's in great condition, and it's not great condition, those are things that are representations under the contract that are separate from the title. Insurance aspect of it.
So, and I'm bringing this up really kind of to paint a broad stroke, even though it's a crazy specific example for anything, lead paints, other types of required under the law disclosure issues. Mm-hmm. It's important for everybody to kind of understand that it's not a title or an escrow issue. You can't go start yelling and screaming, there's a problem here, but there could be a breach of contract. There could be a breach of duties on behalf of the real estate agents. It's kind of just important to know who to
what bucket that falls in. Yep, exactly.
Well, that was the craziest situation I ever had to deal with title. Most of them are real nice and straightforward, but it's always fun to start with the messes. What's the weirdest, craziest, most interesting hiccup you've had on a transaction? And I apologize. I'm throwing you under the bus to say,
when you first mentioned that, I was trying to think, luckily I haven't had too many issues. There's usually I deal mostly in the commercial realm. So you have more sophisticated buyers and sellers, people who are represented by counsel. So, and they do a lot more due diligence in closing a commercial transaction than you sometimes do closing a residential transaction. So I don't run into that issue. The craziest things are I've closed transactions where, hey, we want to sell this property, and you figure out, hey, well, this person's dead, and now you have to go down to their heirs, and then those people are dead. I've had deeds where they're signed by 30 people. I mean, because you're down to the great grandchildren. This property has been owned for, and trying to track those people down. That's pretty interesting at times.
If something like that happens, can you just get all of the heirs, or does it have to go through probate?
No, so we can. So this is kind of where the business aspect meets the title insurance aspect. Sometimes we make those business decisions and assuming a risk as a title company, going ahead and saying, okay, if you do X, Y, and Z, we can go ahead and insure it this way. One of the things we use, especially with a death, is called an heirship affidavit, where you have someone with knowledge. Usually it's signed by someone with knowledge and attested to by someone who's, has knowledge, but is, a disinterested party. And then they just say, hey, this person owned this property. Yeah, I know them. They had 3 children. Here's their names. They lay out the heirship in this affidavit. You record that, and then you have those people sign a deed into the new buyer. And in using that, we're allowed to insure the transaction into the new buyer. Obviously, if you go through probate, that's a lot easier because, usually you have an executor or you have one person who has the right to convey the property, and it's a lot cleaner. But even in doing that, you have to, depending on where they probate the will, and where the property is located, you might have to duplicate that probate record wherever you're selling that other property so people understand the authority that's behind that.
And kind of just so that everybody understands what probate is, if you get a will, it's an invitation to go to probate to deal with your assets after you pass away.
Right.
And when it comes to real estate, you have to do this in every state. I don't know if it's every county, but at least every state that you own real estate in that is supposed to be dispersed through the probate.
Correct. So probate is kind of like you file it. It's kind of like bankruptcy, right? You file you file with the court. It gives notice to everybody. Hey, this person died. They're claiming that they have this property. If you have any claims against this person, come now or forever hold your peace. and you have so much time for that probate for those claims to come in. No one claims, that person who's given the executorship over the estate can then disperse the property accordingly. But yes, let's say if you died in Dallas, Texas, you have a probate in Dallas, Texas, but I own property in Houston, and I own property in maybe even Oklahoma. You would have to get a certified copy of that probate, go record it in Harris County, and go record it in the county in Oklahoma, so that they know you had authority to disperse that property appropriately.
Well, I do have to say, when you're like, act now or forever hold your peace, I was just thinking, oh, is this a death or a wedding, or is it really that different?
It's kind of the same, right?
Sorry, Jasmine. So, maybe if you don't mind taking a couple of minutes and literally walk us through, like, hey, I just got a contract to sell this real estate.
Right.
When does it go to escrow? Is it usually the buyer, the seller, or whoever sends it? And what's the process from there to actually getting to a closing table?
Sure. So yes, typically contract is entered into by a buyer and seller. Either one of those parties or maybe even a broker will contact us, say, we have a contract signed. We need to, open up title. We need to open up escrow. And so they'll send us a copy of the contract. We'll go ahead and put that in our system and get a file number. And then we'll send out a receipted contract that says, yeah, we've receipted it on this day. We'll send a notice to everybody that's in that contract: brokers, attorneys, buyers, sellers, everybody that we have that needs notice, that we have that set up. We'll send them our file number. We'll send them the receipted contract. We'll send them instructions on how to send in the earnest money. Typically in the contract, you have a couple of days to send in the earnest money to make the contract valid. And so we'll give them the instructions on how to send that in. And then we'll kind of let them know that we've ordered title. And at that time, we'll have an examiner start working on title examination of the property. That's the opening of the title and escrow part of it. Usually under a contract, you have so many days to deliver a title commitment. So usually it's about 7 to 10 business days. We'll have a title commitment prepared. We'll send that out to all.
What does that really mean? What's included in a title commitment?
The title commitment will list one, who owns the property, right? A legal description of the property that's being, contemplated into the contract. It will say who we're going to insure. So from the contract, the buyer and at the price that they're purchasing it from, that's the title insurance aspect of it. And then you'll have a schedule, what they call a Schedule B, which is your exceptions to title. It will include any easements, restrictive covenants, maybe even mineral interests that are recorded against the property, any liens that are against the property, mortgages, tax liens, judgment liens. Everything will be listed in the schedules following, the commitment to insure the transaction.
And so by exception, that actually means you get this property, but you're really not getting all of the rights because there's these special exceptions of other parties that may have some interest in the property.
Correct. That's correct. And at that time, under the contract, you usually have so much time to review that commitment. We'll give you copies of the documents that we're saying are affecting this property. And you'll have so much time to review that commitment in those documents and provide objections to title. So, hey, I don't think this easement affects my property. Can you take a second look at it? Maybe at that time, you've also got a survey that shows, hey, that doesn't affect. So, hey, per the survey, this doesn't affect, So there's a lot of ways to attack the exceptions that we provide. The examiners kind of give you a broad, they look at it, they see what they think still affects the property based on maybe what was included in prior deeds as permitted exceptions. A lot of times deeds will say, hey, I deed this to you, but subject to these items that are of record, and so the examiner's looking at all those past conveyances. They go back 40 years at least, if not longer. And they're looking at that whole chain of title to see what affects maybe what's been released, what doesn't affect any longer. And then they come up with their schedule of exceptions to the title insurance. Then you have a chance to look at those too and say, well, I really don't think this affects. At that point, the seller will respond to the title objections, and the title company will respond to the title objections and say, okay, here's what we can do, or here's what we need to take this off. Here's what, here's what the seller needs to provide, or here's what buyer needs to provide. And we'll kind of let you know what we can do. We'll also, if there's certain exceptions that need to be re-examined, we'll have our examiner look at them again and kind of, if it's in a gray area of whether it could be or could not be taken off, that's where our underwriter comes in and says, I kind of agree with buyer or seller over here. I can see where it could be an issue, but I really don't think it's going to be an issue. We'll take the business risk and we'll just remove it. So there's a business aspect of it too, that of what risk maybe the title companies may be willing to take in that process. Once you get all those objections resolved or satisfied to everybody's liking, and you get all the items in that you need to satisfy those objections, then the next part of the contract usually has a due diligence period where in that time, person has so much time to look at different aspects of the property that are not title related. Maybe you look at zoning on the property, or maybe you pull a survey on the property, or maybe you look at environmental issues that might affect the property. Those things, not necessarily title issues, title related coverages. So you make sure all that's in order. Once the due diligence or the inspection period
before we move on, let me ask you about this, because this is actually something that we frequently have to deal with, are the surveys. Mm-hmm. Does that matter to the actual closing, or is that really just between the buyer and the seller to make sure that they've got that legal description, they know exactly what's getting transacted, and are the easements, or is it just kind of here's the boundaries, or here's everything that's been recorded against it as well?
So there's different types of surveys, and you can get them to different, to include different things. There's boundary surveys that will just give you the boundary of the property and say, this is the legal description that's being insured. There's the surveys that then go out and say, here's the boundary of the property. Here's where the improvements are located on the property. Here's where these easements cross this property. Do you have encroachment issues of those improvements over those easements? Maybe you have improvements that are built on the property that extend over your boundary line. Those are major issues that would be shown on a survey. So depending on the type of survey you get and how detailed you get it, those things will come up. It's one of the tools as a title company that we will definitely want to see if you're looking for certain coverages. If you're looking for, and I'm sure we'll go into this in a little bit, but with endorsements to your policy and stuff, there's certain exclusions that come with a standard policy, and those include violations for restrictive covenants and things of that nature. If you're encroachments, those are all excluded. But if you're wanting certain coverages that add those coverages back in, we're going to want to see a survey. We're going to want to see, okay, what's the footprint of this property? Is there anything that is extending over a boundary line? Is there anything that is encroaching into an easement? Okay, that would prevent us from being able to provide these coverages because, we don't have an aerial view. We don't have, we're not certified to go out and look at those boundary lines and go, yeah, that does cover this, but the surveyor does. He can tell you if something does encroach over a property line or into an easement. And for those kind of coverages, we definitely need a survey. So it's one of the most useful tools you can get. Closing a commercial transaction, most everybody gets a survey. Residential, not so much. I don't think people are always concerned about that. But I will say this: most residential transactions do get a survey only because the lenders require one as part of giving a loan. And so, because there's coverages they want on their loan policy that require a survey.
And when there's a lender's policy versus just a buyer's policy, does the lender's policy really cover everything, or just the loan? Or how does that work when you're having to actually choose what type of coverage you're going to get for the transaction?
Right. So, yes, no, they cover two separate parts. The loan policy only covers the lender's priority, right, of their loan versus any other liens or matters. Except for those that are accepted to on their policy. And it only exists for the life of the loan. So once that loan is paid off, that loan policy is no longer valid. The owner's policy, on the other hand, it exists for the lifetime of your ownership of that property. You own it 100 years, it exists for 100 years. And it includes, it's saying you own the property, you have all the rights to that property, subject to the exceptions on the title policy, but which are the matters of record. But, if anyone comes and claims that you don't own this property, then your insurance kicks in and covers that kind of defect. So they cover two different parties, two different, aspects, and they have two different lifespans based on, who's being insured.
Got it. And when it comes to like the owner's policy, to go back to my example, if the guy that bought the house from the wholesaler, can he just go back to the original escrow company that made the mistake and say, hey, you didn't get me good title? I want my money back? Or does he have to like follow a particular chain or process?
So his recourse is going to be against the title company that closed his particular transaction when he purchased it from the wholesaler. If he went back 3 chains back to when that guy sold to the wholesaler, they're going to say, well, hey, I didn't issue a policy to you, and I didn't close this transaction. I didn't have any relationship or contractual obligation or fiduciary responsibility to you. So, you making a claim against me. Yeah, great. So that's why it's better that he makes the claim against the title company that closed his particular transaction. Let them go down the chain, because they're going to go from Chicago Title is going to go to First American. First American is going to go back to whoever insured that original transaction. And they'll deal with it on the back end.
Perfect. All right. So we've done our due diligence. We've got our title commitment. We objected to everything that is an exception on it. And now we're moving towards that closing. Mm-hmm. Where does the lender come into play, and what matters? What do we got to think about when we're dealing with the lenders and the loans when we're buying?
So just like the buyer and seller have a period to object to title, lenders will also get the title commitment at that time. Typically, as soon as your lender gets involved in the transaction, they're going to give the title or escrow company notice that they're involved and they want a loan policy for this amount. You also have to provide them the title commitment. They're going to provide an objection letter just like the buyer and seller would have one between them. So you have to answer the lender's objections as well. And you have to get them satisfied on what their loan policy is going to look like. And in that process, once you get buyer and seller squared away on objections and due diligence and everything is squared away on their side, lenders also squared away. Then at about that time, about 2 weeks before closing is when we typically see draft closing documents being circulated. The lender will typically send the buyer their draft loan documents based on the terms that they agree to in the loan. And then the deed and the title affidavits and everything will start circulating. So everybody kind of sees if they have an objection or a revision to any of the documents, they have time to get those objections, revisions in. And then once it's all papered up to everybody's satisfaction, typically a couple of days before closing, the title escrow company will coordinate with buyer and seller and lender signing those documents. Sometimes it's at the title company. Sometimes if those parties, like I deal on a national basis, so I'm dealing with people that are in different states all the time. And sometimes I have to involve other title branches in those states, or I have to involve mobile notary services to go out to those people, get them to sign the documents and send all the documents back to me to merge together. Once I get all the documents in hand, usually the day before closing or the morning of closing, I will circulate to everybody a full set of closing documents that's signed. I'll send to the lender the loan documents. I'll send the buyer and seller all the conveyance documents. At that time, hopefully the buyer's already sent in and the lender has already sent me their money in escrow. So I'm holding the documents, the original documents in escrow, and I'm holding the money in escrow. When I send all the documents out to everybody, I'll ask, hey, I got everything that I need to close this transaction. Do I have your approval based on what you're reviewing to go ahead and close? And if they give me approval, then we'll fund, we'll record, and then within a couple of weeks of closing, we'll issue a title policy and send out the recorded documents and things of that nature.
So I've closed hundreds of transactions over the years. A lot of them have been like the large commercial multifamily office buildings. Mm-hmm. And I got to say, when it gets to that day of closing, you make it sound like a very peaceful, calm experience. Is it just me that never has a peaceful, calm closing?
Well, Mel likes to tell me I'm like a duck. I look like I'm swimming on top of the water, but my feet are just churning underneath like a million miles per hour. And sometimes you feel that way. There's a lot of moving parts and pieces for sure. And especially when people are signing in counterparts, in different locations and sending things to you, you're subject to, well, did the FedEx deliver it on time? Did the UPS deliver on time? Did they sign it in the right place? Did they miss a notary stamp? I mean, those type of things happen all the time. So by the time I get to them, I'm having to go through all of that. Those are the things you're worrying about as an attorney. Like, did my client do exactly everything they were supposed to do to get it to him? And so there are a lot of moving parts, but nothing that's not fixable, right? And the good thing is, I don't think anything, dealing with more sophisticated parties on a commercial transaction, okay, this document didn't get notarized, but hey, I promise I'm going to get it done. Hey, hey, can y'all close on a PDF? Sometimes they scan it in a revised copy and hey, it's already in FedEx. Here's the FedEx number. He'll get it tomorrow. Everybody's okay. Hey, that's fine. That's a good solution. Let's close. Let's get this done. So there's always things that come up in a closing. I definitely I gave you the kind of the easy, smooth answer, but yes, there are issues that do come up, and that's the reason you use people that have the experience and the expertise and the knowledge that have dealt with these issues
I gotta say, when it comes to that closing day, and the half hour, the 15 minutes just before it's closing, and you see with these larger transactions, you have so many different people involved, from the attorneys to the parties to everybody. When it starts that, every minute there's just emails going out, one after another. It's like such an excitement, other than my blood pressure, that is like, okay, I need a break here. And then you get that message, buyer approves, seller approves, lender approves, escrow officer. Okay, we're close the transaction and dispersing funds. And then all of a sudden you just have this, we made it.
It's definitely a good relief feeling.
Well, I always enjoy that part. Well, especially when it's all done, and you got that wave of like, success. So, and if anybody that is listening has any questions, please add them. Otherwise, we're just going to keep hitting different topics, because when it comes to escrow, when it comes to title, all of this is really important. And I wanted to get it kind of straightforward from the horse's mouth, from the guys that have been doing it forever, and kind of the next getting more complicated, writers and the different policy options. Like, people don't really understand that they can actually be different writers, and what does a writer even mean?
Sure. So yes, there's definitely different policies out there. I think we always covered just the basic difference between an owner's policy and a loan policy. But, Texas is unique in that they have their own form of title policy versus other states who use what's called an ALTA policy, which stands for American Land Title Association. They're kind of a governing association that gives you model endorsements, title insurance, policies and procedures that states have the options of adopting or not adopting. Texas has chosen to go have their own title association, the Texas Land Title Association, and they have a completely different set of, policies and procedures that Texas has adopted. So Texas is a little bit unique in that standard, but from Texas, you have just basically your owners and loan policy. And it's a TLTA policy. In other states, you have what's called the ALTA policy, but you have an ALTA standard policy, which is kind of just your standard run-of-the-mill policy with the general standard exclusions. And then you have what's called an extended policy, which eliminates some of those. You pay a little bit more, but you eliminate some of the exclusions in that policy. So it covers a little bit more. It's like your homeowner's insurance, right? I mean, you get a homeowner's insurance policy, they're going to give you a standard policy with such a deductible. If you want to lower your deductible, you pay a little bit more. If you want wind and hail coverage, you pay a little bit more. You want water and damage coverage, you pay a little bit more. So, those are the that's the difference between a standard policy and an extended policy for title insurance as well in those other states.
Got it. And so when somebody says we have an Alta policy in every state, that basically means the same thing, right?
Pretty much, yes. There's a standard form that either is adopted, and every 5-10 years they come out with a new form, and that's adopted. So some states might still use an older form, some states might use a newer form, but in general they're pretty much the same. You can go onto Alta's website, and you can pull what their policy cover, their standard policy cover, would look like, and you can read all the exclusions that are in there. And then that's what you mean by going to, hey, we're going to issue an Alta policy. This is the type of policy policy coverage, you're going to look at.
So since Texas does it a little bit different, could you still get an Alta policy, or it's not even available in the state?
It's not available in the state of Texas. So outside the state of Texas, Alta is available. Inside the state of Texas, it's a TLTA. There's only one other state that uses their own form as well, and that's California. They use the CLTA, with the California Land Title Association policy, but they also offer an Alta policy on top of the CLTA. And actually, there's a lot of similarities between the CLTA policy and the Alta policy. They're very similar and they mirror each other quite a bit.
Perfect. Well, that's kind of comical that you got the two biggest states saying, we're going to do it our own way anyway. When, as an example, somebody's closing in different states, they're buying properties across state lines. Mm-hmm. Is the process always generally the same, or is there some instances where Ohio is really weird, or some areas just have completely different ways to close a deal?
The general closing process is the same closing nationwide. There are different procedures for recording in each state. So some of the recording aspect of it may take a little bit longer. A lot of East Coast states, some Midwest states, and certainly the West Coast states, California's being one of them, they all have a little bit different recording procedures. In some states, you even have the county has to actually take your document, look at it. They have an attorney look at it. It's, even though you've submitted it, it may not be recorded for 2 weeks before, it's vetted. And so part of closing with the title company and escrow company is ensuring that gap, which they call that the gap between the time that you actually sign the deed and ensure the transaction and the time that it's actually recorded. So that gap period of time is actually insured in your title policy.
So kind of an interesting quirk of different states, the security interest, a mortgage versus a deed of trust. Is there really a difference? Or when somebody says, hey, we have a deed of trust or we have a mortgage, is it basically the same thing that they're talking about, just state dependent?
Yeah, basically the same thing. It all kind of boils down to the foreclosure process and what the laws are, how the laws are written in that state, whether would you really call it a deed of trust or a mortgage, because in certain foreclosure states, you have to have a trustee, an independent third party that you're basically putting your rights into so that they can close on. But there's always ways around that. As you know, in Texas, trustees kind of more a name to put on a document than really they have all the authority, because you can always substitute those trustees out. It really doesn't mean anything. So for all intents and purposes, the mortgage and deed of trust are the same. It's just whatever the state law is how you kind of name that document, but it does the exact same thing, and it's insured in the exact same way.
And that's it's just something that completely confuses people, because everybody thinks I have a mortgage. And that's kind of true. It's kind of not true, depending on the state that you're actually in. So I'm sure the guys sitting behind the table in all the escrow companies are just like, ha, 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 you don't have a mortgage. In terms of document production, and let's just stick to the commercial side of things. Do you actually prepare documents for the closing process, or is that always done through the buyer or the seller's attorneys, whoever may, under the contract, say you produce the documents?
It's dependent. I typically, with my clients, they like me to prepare everything and circulate that. Sometimes the attorneys on each side would prefer certain forms be used, so they'll either, provide those forms or prepare it themselves so that they use that particular form. But in a lot of cases, I do prepare mine. Now, there's other closers I deal with that I work with that don't feel comfortable preparing those documents. Of course, they're not, not all of them are licensed attorneys themselves, so they don't feel comfortable preparing those. So they'll rely on the parties to provide those. Now, there are cases where neither of them are represented by an attorney, buyer or seller, and we'll have to get form documents from our local title offices in whatever state we're dealing with that will that they can help to help them in the process. But a lot of times I do prepare
and I would love to say, in my experience, the cheapest ways to get the documents done is to rely on the escrow company to actually produce them if you don't have crazy things going on. Oftentimes the lawyer's like, we have to use this form because we need this 75-page purchase agreement that we're going to bill by the hour to negotiate section by section by section. Yeah. So I know a few specific firms that I know what to expect when I see it. And it's just like, okay, this is going to take forever. And we're unique in both the real estate and the getting the deals done space because we charge a fixed fee kind of based on what we expect to happen with the transaction. We do a lot of syndications and capital raising structures. And with that, we're always charging a fixed fee. And I hate when it says, okay, well, I know this firm and I know they're going to make it long, complicated, and time intensive. So I'm sorry, your fixed fee's going to have to go up. At the end of the day, it's time and headache. And so actually that's a general point to everybody. You just got to pay attention to who you're working with as your attorney, because you don't want your attorney to be that guy that really racks it up as much as possible. But when you do have those attorneys and they may convince you that we're the best people ever, so you have to trust us to do all of this stuff, you're actually can be making it way more expensive on all sides. And the big question is, Eric, is it really that helpful?
Not always, because either I have to correct them or, I will say this, a lot of times attorneys do like me to prepare things because they would rather spend the time just reviewing it, doing a quick cursory review and kind of knitting it a little bit, as opposed to having to spend all their time drafting it. I mean, a lot of attorneys, I will say, are cost conscious for their clients, but some are not. Some like to argue about everything. And I would say that's more the exception than the rule. But, with that said, yes, I mean, there are times where they draft something and I'm like, no, that won't work here. This state doesn't allow this, and you have to have this particular language in the deed for this state, so each state's a little bit particular. And the good thing is that I've been doing it for so long in so many states. I know the ins and outs of each state and what they require. Some have a particular notary that you have to use, and some have, certain language you have to put in there about whether it's your homestead or not homestead, or your residence or not residence. Certain warranties have to be in there in certain states. So, knowing those things and using those, throughout the years, using the same forms over and over and over again, I'm able to produce things fairly quickly, cost effectively, and things that will help get the transaction recorded and insured and smoothly, done.
Well, I love it, and definitely appreciate everything that you and Mel have done. Anybody that has registered, we're out of time now, and I know lunchtime is up. Well, we've got the contact information in the chat. We'll also just send it to everybody as well. So we'll make sure that anybody that needs the pros, we're here on the transaction side. Eric's there on the closing side. And at the end of the day, we're just there to do good for the world and see deals happen.
That's right.
Thank you.